Harassment and sexual harassment law is an area every employer needs to take seriously, but rule changes coming in October 2026 will raise the bar even further. In this video, I'm joined by Juliet Irving, Director of HR Operations at Impact HR, to talk through what's changing, when it takes effect, what it means in practice for small businesses, and some of the most common questions employers are already asking, so you can get clear on what to review and what to do before October 2026. So, Juliet, let's start with the basics. What exactly is changing with harassment laws in October 2026?
So from the 1st of October 2026, the duty to prevent sexual harassment increases from reasonable steps to 4 reasonable steps. And also from the 1st of October, employers can be liable where workers are harassed by third parties. So this may be their clients, customers, contractors and suppliers. And it's important to note that this covers harassment, not just sexual harassment.
Great, so now we know what's changing legally. What do the harassment law changes actually mean in practice for small businesses day to day?
It means that employers will be expected to move from a reactive approach to a proactive one when it comes to preventing harassment of their workers. It is something that SMEs can't assume is only an issue for large businesses because it is applicable to all employers, regardless of their size. Employers will therefore need to think more seriously about manager training, raising awareness against the whole of their workforce, and ensuring that there are clear reporting channels, properly handling incidents as well that do occur, and also carrying out risk assessments to identify those higher risk areas in their work environment. For example, higher risk areas may be like career-facing organisations, or those in hospitality or care, or who work out on the road, or even in social settings. They all may present higher risk situations for this day. So overall, though, workplace culture is really important because this sets the tone for an organisation. For example, having that zero tolerance approach to harassment and dealing with any issues that do arise in the right way. The biggest risks for employers and SMEs in general would be informal processes or lack of awareness of the new norms and any training that perhaps hasn't covered the whole of the workforce.
Okay, amazing. So now that we've covered what's changing and what it means in practice, I want to get into some of the questions we're hearing most often. So I've got here some of the most common questions we've been hearing from small business customers at Breathe, as well as through our network of Breathe HR consultant partners and the clients they support. So let's start with this one. Juliet, what does the government actually mean by taking all reasonable steps to prevent harassment and sexual harassment? Is there any formal guidance?
Okay, so what the government means by all reasonable is that employers should take measures that are appropriate and proportionate to their size of organisation, the resources that they have available, and also their sector, and if there are any particular risks that they face as a business. So there isn't a one-size-fits-all checklist, unfortunately. What is reasonable for one organisation, for example, working in an office environment, will look quite different to what's expected of the large employer and commercial sites, where staff might be customer-facing or night working. One source of information at the moment that we do have is from the Equality and Human Rights Commission's guidance. So they've put together an 8-step guide for employers, and it sets out that employers should carry out risk assessments, have clear and up-to-date policies, provide effective training, and making it easy for our people to report concerns, that they respond promptly to any concerns that are raised. But also monitor workplace culture and regularly review whether the measures that they are putting in place are actually working. The key message is that employers should be able to demonstrate the ongoing and active approach to prevention. It's not enough just to have a policy alone or to provide a training session every few years. If an organisation is challenged on harassment, the question is going to be asked, what practical steps did that organisation take to reduce the risk of harassment? And the organisation then being able to evidence those steps is likely to be just as important as actually having taken them in the first place.
Okay, great. Do the new harassment and sexual harassment laws apply outside of the workplace or working hours, for example, in social settings?
Yes, potentially they can do. And so what we're talking about here is whether there's a sufficient connection to work. So harassment can occur at work-related social events, for example, training courses outside of the work office, conferences, networking events, and things like Christmas parties or summer parties. Even things like Teams messaging outside normal working hours can only amount to harassment. So in those situations, employers should assume that their obligations still apply because the conduct that is arising in the context of work. So this means that employers are expected to think about where any risks of harassment might arise, and that includes those work-related social situations. For example, if an employer organises a staff party where alcohol is available, then they should consider what reasonable steps are appropriate then to prevent harassment from taking place. So it might be things like communicating expected standards of the behaviour at the party. So the safest approach for employees is not to focus on the location or the timing of when these issues may happen, but to look at whether the behaviour is sufficiently connected to work and whether it could affect employees and force employees.
Cool. So another question I've got here is, what should harassment and sexual harassment training look like in a small business?
Well, for a small business, training doesn't have to be massively complicated or really expensive, but it does need to be meaningful. So the aim is that it's not a tick box exercise that HR has absolutely to do. It's to people understand what harassment may look like in the work setting, what standards of behaviour are expected, or what staff should do if experiencing or witness inappropriate conduct that may lead to harassment or etc. at work. So training should explain what harassment and sexual harassment is, what can be done through practical examples that are relevant to that organisation as well. So it's really important that the examples that I talked about in the training sessions are relevant and meaningful to that workforce. The training should also explain that organisation's policies in relation to harassment and sexual harassment and the relevant reporting procedures as well. It's also helpful to cover the role of the active bystander in these situations, so employees understand their role in helping to create and support a respectful workplace. So we also advise that managers should receive additional training to the general workforce because they need to know how to recognise potential issues, how to respond appropriately when concerns are raised with them, and understand when they should be escalating matters as well. And this is particularly important in a smaller organisation where those managers may be the only point of contact. And don't forget refresher training, so it shouldn't be a one-off exercise. It is important to refresh knowledge of your existing staff and also capture any new starters as well, and generally keep up any changes to the legislation around harassment and sexual harassment. And in keeping records as well of the training, so anybody who's attended training, when it was held, where it was held, who it was delivered by, as that can then help demonstrate the reasonable steps that an employer has taken if there is an issue. So ultimately, a shorter, engaging session that employees will understand and remember is likely to be more effective than a lengthy training presentation.
Yeah, record keeping is definitely an important thing with the FWA, the Fair Work Agency. Cool. So next question I've got is, how should managers and small business owners respond if someone does raise a concern or complaint around harassment?
Yeah, so the most important thing is not to ignore it and deal with it promptly in a timely manner. So even if a concern is raised and it seems informal or it seems relatively minor, then managers should always take it seriously. The first step is to investigate the concerns raised, and this is really about listening carefully to the employee, what are they saying, and avoid jumping to any conclusions. So the employer should then consider what immediate steps are needed to protect those involved, and this could depend very much on the circumstances. So they might include temporary changes to working arrangements just whilst the insurance is standard. And don't forget that any measures should be proportionate and should not disadvantage the person who was raised. So a prompt and fair investigation means gathering all the relevant evidence, speaking to witnesses, if there are any, and giving everyone involved an opportunity to explain their account. And it's important to keep clear records throughout this whole process too. And for small organisations in particular, consider whether outside support might be needed. So in cases where the allegations may be quite serious or may involve senior members of staff, obtaining independent HR advice and support can really ensure that the process is as fair and productive as possible. And when responding to a concern of harassment, remember that dealing with the complaint is only part of the process. So once the matter is concluded, it's also best practice for the organisation to look at learning points. For example, what lessons can be learned from this? So do your policies need updating? Is there training needed? Are there more general cultural issues that need to be addressed? This action, again, of the follow-on is about that preventative duty that's expected from employers to reduce the risk of any similar issues.
Great, thank you, Juliet. The next one is, do you need both a harassment policy and a harassment risk assessment? And if so, what should they include?
Yes, is the short answer. So we find that organisations need both a harassment policy and a harassment risk assessment. So they serve different purposes, but together they help to demonstrate that the employer is taking those proactive steps to prevent harassment in their workplace. So what should they include? The harassment policy sets out the organisation standards and procedures. It will explain what harassment and sexual harassment is. It will set out what the processes of how employees can raise concerns and outline how those complaints will be investigated, and generally reassure staff that complaints will be taken seriously. The policy should also make clear what standards are expected of managers and where relevant of third parties, whereas the risk assessment is used to identify where problems are most likely to arise and decide what preventative measures may be needed. So employers should think about factors such as lane working, customer facing roles, night working, power imbalances, or isolated workplaces, for example. And the assessment should then identify practical steps to reduce any risks that are identified. So whether that's additional training, changes in supervision, reporting arrangements, or changing working practices as needed. But ultimately, the harassment policy and the harassment risk assessment are two separate documents, but they work together. The most important thing, these documents should be live documents that are reviewed regularly or known about and become a real lived policy in stage.
Yeah, that's great. There's probably a lot of instances I can imagine of policies and documents being in filing cabinets or desktops that aren't touched for a long time, and you have no consent or confirmation that people have seen it or read it. So yeah, that's definitely a good one. Okay, great. So our last question is, how can you prevent and risk assess harassment and sexual harassment by third parties? I know that's a new kind of thing coming into effect.
Yeah, so this is a new preventative duty that makes it clear that employers are expected to take reasonable steps to reduce the risk of harassment by third parties your staff come into contact with at work. So this may be their customers, their clients, service users, contractors, or visitors to members of the public. So the starting point is a risk assessment where employers should identify where employees are most likely to come into contact with third parties and whether there are any particular risk factors. For example, those client-facing roles, lone work conditions, home visits, they all may present a higher risk. Once those risks have been identified, employers should consider practical measures, which might include that clear zero-tolerance policy towards any inappropriate behaviours from customers or clients. This may be through their documentation, such as their business terms with their clients, or even displaying notices setting out the expected standards of conduct. For example, poster up on the wall of the office or the shop floor. Training staff and managers on how to respond to inappropriate behaviour as well and being able to identify it. Providing clear reporting routes and ensuring that employees know that they will be supported if they, for example, refuse service of somebody who is displaying the inappropriate behaviour, or if they want to remove themselves from an unsafe situation where needed. And it's also important to record and monitor incidents. So if complaints repeatedly involve the same location or the same client or the same type of situation, employers should review whether additional measures are needed. And remember that prevention is always that ongoing process rather than just a one-off. Ultimately, employers aren't expected to eliminate every risk or guarantee that harassment will never occur. I think that's going to be impossible, but actually the legal duty is to take those reasonable steps to prevent it.
Amazing. Yeah, that's all really useful stuff. I think it's definitely going to be a learning journey for lots of businesses. We have covered a lot in this video in a short space of time. So just to summarise, harassment and sexual harassment laws are changing in October 2026, requiring businesses to take a more proactive approach to harassment prevention. And the biggest takeaway for small businesses watching this video is to start preparing now. Don't wait for a harassment claim to happen. Use the time before October 2026 to review your policies, refresh training, think properly about risk, and make sure managers know what to do. The businesses in the strongest position will be the ones that show they took prevention seriously before an issue arose. So, just wrapping up, if you've got other employment law related questions, you can check out Breathe's Employment Law Hub on the Breathe website. It's linked in the description below. where we have plenty of free resources and information about all the employment law changes coming in 2026 and 2027. And if you'd like dedicated HR support or expert advice, you can email Juliet at juliet.irving@impacthr.co.uk or visit the Impact HR website, again, all linked in the description below this video. Thank you so much.